So our next session is going to focus less on Europe and MiCA and more on decentralized finance. The name of this panel discussion is rather long. I'll save it until the end because it's a mouthful. But the people who will join us for the panel discussion for sure have plenty to say about it. And you may have an opportunity this time, since you are lucky enough to still be with us here, ask a few questions that may be to your benefit. So the four experts that will join us now for the next panel are Clemens-Emanuel Gutwenger from Clifford Chance, Ariel Ben Hattar from Lenz Staehelin, Catrina Luchsinger from MLL, and Ronald Kogens from MME. Some of the panelists know each other rather well. I think Ronald and Catrina, perhaps in particular, know each other well. And their topic will be decentralized financial market infrastructure. Do they even exist under applicable law? And if so, when is true decentralization given? I am very, very interested to see how many insights we can have on this seemingly very broad topic.
Okay, so welcome everybody to this panel, and thanks for staying here because it's going to be a very interesting panel, I'm pretty sure, and a very interesting topic. So I think the Web3 industry will soon face one of its biggest challenges because regulators are gearing up and they are start scrutinizing, in particular, DeFi infrastructures, and they basically test whether they exist, whether they should exist or not. We have recently seen that in the US, the SEC has sent a Wells notice to Uniswap. Uniswap responded and they argued, for example, that Uniswap is an autonomous protocol on Ethereum. It's not controlled by anyone, it's just a pure piece of software. They also argued that Uniswap Labs is an innovative software development company, nothing else, and that there is no group, organization or association that is operating the protocol because it's autonomous. Now, jumping into this topic, I'm very happy to have very well-known speakers here. So on the one hand, we have Emmy from Clifford Chance. He's a financial market lawyer and capital market lawyer in Europe and the UK. And then we have Catrina Luchsinger, a very experienced traditional financial market lawyer, but also in the new Web3 industry from MLL. And then we also have Ariel from Lenz Staehelin, a capital markets and financial market lawyer, also very active in the CMTA, the Tokenization Standards Organization. So I'm very happy to have you here. And I think I would like to start with the first question that I would like to ask each one of you, that what do you think? Do decentralized financial market infrastructures exist? And if so, when is decentralization given? I know, Catrina, do you want to start?
It's a very good question because, I mean, we are talking about the blockchain, which is per se decentralized. It's one of the key criteria. So defining when we actually have an autonomous organization versus an organization which has a centralized element I think has to be looked at in its entirety. And decentralization comes on so many different layers. So you have the first level blockchains, you have the applications on the first level blockchains, as you said, Uniswap, for example, working on Ethereum. For me, the question really is, what is the purpose? What is the core purpose? And first level blockchains have a different purpose when looking at it from a financial market regulation than actually providing financial market services. That is not their core reason for being. So from a regulatory point of view, I think it can only be actual applications geared towards providing something which from an activity point of view is equal to what a financial market organization would do. So I think there are actual decentralized organizations which should not be regulated, but how to carve them out, that's going to be part of our discussion.
Amy, what are your thoughts on the question?
So, first of all, thank you very much. I think this topic is really, really interesting and really topical, as you said. And I think, especially from a UK and EU perspective, there has been a little bit of confusion about the topic, especially from a regulatory perspective. So, and particularly because recently there have been a couple of policy papers from the Bank of England. There was a policy paper focusing on the financial stability risk. Also from ESMA, there was a policy paper, again, focusing on the financial stability risk, where we usually have policy people from the regulators looking at DeFi FMIs and assessing them. And when I read all of these policy papers, the first thing that I think is, this was not written by a lawyer, which is a good thing because it's very interesting to read. But also, the problem is that the analysis is not carried out from a legal perspective. So, from a legal perspective, I would say the first thing to bear in mind is that under UK and EU law, FMIs are not activity triggered. So you don't become an FMI. There are a couple of exceptions, but you usually don't become a CCP by carrying on CCP activities. FMIs are usually recognition or designation triggered. I think that's the first point to remember. The second point to remember is that underlying, you still have regulated activity regimes, which are activity triggered. And I think that's the level that the analysis, the legal and regulatory analysis, should take place. It's the activity-based analysis, and there we have, depending on the relevant asset, for securities we have MiFID, for crypto assets we have MiCA, and that's the analysis that I think we should look at. And I think the outcome is exactly the same as Catrina said. It depends on what the activity is. It depends on what the relevant FMI is doing. If the FMI is doing something that from a traditional regulatory perspective is a regulated activity, then I think regulators will enforce and will pursue these entities. And so that's where the analysis should lie. But in summary, I think from a pure regulatory perspective, I don't think decentralized FMIs as such exist at the moment. It's the activities that we need to look at more than the concept of an FMI.
And I would agree with that. I think regulators have been highly skeptical that there are such things as decentralized financial market infrastructures, probably also because they understand that what at least some are trying to do with this is to say this is so decentralized that it cannot be regulated. And as you said, Amy, I think the regulators are likely to see it differently and look at the activity, and because in a country governed by the rule of law, such as Switzerland, if we have decided that operating a trading venue is an activity that requires a license, the fact that you have structured this in a way that you have burned the keys to control this infrastructure, I mean, is it really right that this sort of alleviates any regulatory burden from you? I don't think regulators would agree with that. And I think we are in this situation also because there is sometimes a bit too literal a reading of the rules, which says, you know, if you have a financial market infrastructure, it has an operator, and you sometimes see, or at least I see sometimes in my practice, project teams that will say, well, but we're not the operator, so how can we regulate it? And I think in Switzerland, at least, this literal reading of the rules, it might maybe work in the US, but I don't think it works in Switzerland because we're looking at this from an anti-circumvention perspective and from the point of what is actually going to be done as part of this project.
And I think this anti-circumvention is a key element, because what the Financial Market Authority does is basically look at who is gaining from setting up such a decentralized organization. And in particular in the financial market, you will, in most cases, you will not have a situation where there is not somebody who has benefited from the sale of tokens, from service fees or something else. And that is where the financial market would go and first of all try and find the starting point for regulation. And only if you would do it for totally altruistic purposes, you would be setting up a financial market infrastructure, would not take any money and would allow a peer-to-peer situation, would it really, I think, start to be a truly autonomous organization.
So basically what I understand from all of your statements is that financial markets, relevant activities, so a financial market infrastructure activity or a financial service activity should be subject to regulation because that was the idea of the laws, and if you do a same activity then you should be regulated the same no matter if you're saying that, as Ariel said, we burned the key so we are not responsible anymore. But of course I would like to challenge that a bit because, I mean, you could also argue and say, I mean, we burned the key, it's out, can it be seen something like nature? I mean, it's just here, it's just given, it's not anymore controlled by humans. And I think based on that, maybe I start again with Emmy. Does it make a difference? I mean, financial market law can only apply if obviously there is a relevant activity. And I mean, in Web3, you see there are different layers. So we have the layer 1s, we have layer 2s, we have layer 3s, which are protocols on top. We have even maybe layer 4 or 5 until the application or end user interface. And what is your opinion on that? Is basically just a layer 1, there is a possibility that you can launch a protocol which is a financial market infrastructure, so basically the whole layer 1 should then be regulated, or what is your opinion on that?
And that's a really interesting question, but before I'm going to answer it, I did not say that DeFi should be regulated. Okay. I think what I was trying to say is that I think regulators will think that they already are regulated or subject to applicable regulation, and I think that's the point I think everyone should be a little bit careful about, as we've seen, as you said, with Uniswap. I'm going back to your question. It's a really interesting one, but it's not an entirely new question. So that's a question that, at least in the UK and also in the EU, has come up before in different contexts, in different sort of historical circumstances. We've always had the question of what is a newspaper doing, for example? If as a financial services company you post an ad in a newspaper, even a broadsheet, a printed newspaper, is this newspaper carrying on regulated activity? Is it arranging, is the concept in the UK? Is it arranging deals in financial instruments? Is it making arrangements with a view to these transactions? And there is very established case law, there is established guidance, which is technology neutral, and I think that's the beauty of the UK regulatory regime, but I'm sure it's the same in Switzerland. But from my perspective, that's the beauty of it. So this is a concept that comes up again and again and again. The other question was, for example, what about the internet? Is an internet provider, are they making arrangements in respect of financial transactions if they host a website from UBS, for example, where you can post your financial, so your orders for share trades? And there we have an exclusion in the relevant regulation about mere conduits. So actors providing mere conduits and mere means of communication, they are excluded from the regulation. And there is a host of applicable case law that can be equally, I think, applied and would be equally applied to the question of layer 1. So I think layer 1 is very likely to fall outside of these activity-triggered regimes, but only if all they're doing is mere communication. So as you said, as soon as there's mere communication plus additional services being provided, plus profit being gained from specifically from the transactions, then even under existing guidance and existing case law, the mere conduit exclusion would no longer apply.
Ariel, what is your view on that?
Well, when you mentioned nature, I think we really have to distinguish what is, and to Amy's point, also purpose-built to host financial transactions. If you create a layer 1 protocol that is really intended to be a central securities depository and a clearing organization, the only thing you can build on that layer 1 protocol is that. I think it's very hard to argue that this is not an activity that should be regulated, and that those who have put in the money and have a real stake in this, at least originally, should be completely off the hook. At least that's how regulators would think about it. Now, of course, if you have a layer 1 protocol like Ethereum, where you can build all sorts of different things, I think there the nexus with financial markets is further away, and there's a good argument, I mean, in my view, convincing, that this is something akin to a newspaper or to a Bloomberg chat, on which you can build something. You can use a Bloomberg chat to trade every day, but you can also use it to talk about the news and who is going to be the next president of whatever country.
Mm-hmm. Yeah, I think that is absolutely correct. If you have a very specific purpose-built first layer, then you would also the first layer would fall under the ambit of regulation. There is at present one case in Switzerland where the people who have built this first layer, they unfortunately on their website, all they were really advertising was being able to use this first layer for specific financial transactions. And the inquiry of the regulator has now just started. So I think that is correct. If it's purpose-built and it's a question of how you yourself then advertise the first layer you have built. And very often, again, as in this case, it is very centralized, in particular, and actually at the beginning of a new blockchain, the centralization is much, much bigger. You know, it takes time until it really becomes decentralized. So the risk at the beginning of a project to be caught by regulators is in that case bigger.
But I mean, let's take, for example, Uniswap again. I mean, they're also arguing in their response that the protocol was not built for securities, and it's even not clear which tokens qualify as securities or not, because I mean, I would say most of the tokens in the Web3 industry, they are not built as securities like equity or bonds or something like that. And does it make a difference? So if someone is building a protocol which allows to trade digital assets, which is basically on Ethereum, it's just a standard, technical standard, where it can represent whatever it is, would that still mean that it's then be seen as a financial market infrastructure? I don't know, who want to take it?
So it's a tricky one, but I think generally we know that the SEC are quite aggressive in this space. And also just to add to Uniswap, because before this discussion, I quickly talked about the SEC approach with my colleagues in New York, and they flagged to me that there was a previous case in 2018 where Ether Delta, I think the exchange was called, was enforced against, or an enforcement notice was served, and the founder of Ether Delta apparently found the SEC's either aggressiveness or the SEC's views so convincing that he actually settled the case. So there already is a settled case with regard to a DeFi FMI in the US. I think generally it really always comes down to the activities, and I think the one point I would just say again from a UK perspective, it really doesn't depend on which layer we're looking at. It doesn't depend on what we call it. At the end of the day, what the regulator will look at, so usually these regulators are financial markets lawyers, they're not very imaginative. They just look at it through their lens and ask, what are the activities? And if there are activities that are regulated activities in respect of regulated assets, they will, I think, generally find someone to enforce against, as the SEC did. And for example, we had discussions also in the in that context about DAOs, where often it's said, well, they're not, so you can't enforce against them. From a UK perspective, DAOs are very clearly general partnerships or unincorporated associations, and they can very much be enforced against. So it's the activities again that.
But I mean, at the end, so if there is no intention to create the financial market infrastructure, now let's use Telegram. I mean, Telegram today is the messenger for all kind of people, whether it's terrorists, whether it's drug trafficking or whatever, and it was not built for that. And I mean, even with a decentralized protocol, I mean, you can have tokens which are meme coins, you can have tokens NFTs, or you can have whatever you want that has no relation to financial market. And I don't know, Ariel, what do you mean from a Swiss perspective? Would that make a difference, or would that be an argument against FINMA that you can say, I mean, that was not our intention?
I think this is an argument. If I were counsel to Uniswap, I would be all over the place with that argument. But if we take a step back and try to look at it more objectively, I think if it just so happens that occasionally there will be a security that gets traded to your system because it slipped through the cracks, etc., yeah, that should not be considered operating a trading venue for securities. But if your system has been known to operate in this manner for a long time, and there are liquidity pools where the only things that are traded are securities, and there is still someone that maintains some form of grip, and maybe I'm jumping to another topic we'll discuss, but if there's someone that maintains some form of grip or significant influence over this project, then the question becomes, why have you not used that influence to make sure that those transactions in securities did not happen? And in the case of Uniswap, I'm not familiar with all the details, but I could imagine that this is not going to be so easy to show.
Mm-hmm. I mean, the whole question comes from two sides, doesn't it? On the one hand, the codified laws, in our case, which are open for interpretation, and then on the other side, the enforcement of the laws, which is a circumvention enforcement, which requires broad interpretation. And the tools which the regulators have and the Swiss regulators use are, first of all, you don't have to have a legal entity. They can bunch groups of people and say, you are acting in cooperation, so we're taking you as a group acting together. Like that, you can basically pick on different people in different jurisdictions, but if there's somebody in Switzerland, they can also pick on that person. And the other thing is they have so-called fictions, and those are the most scary parts of the enforcement, where they say, well, you have created A, but we think actually it's a fiction, and in the fiction we are drawing all the activities into Switzerland, for example. It's something which they use if you have banking activities in BVI, but you're running the bank out of Switzerland. They would say, well, in fiction, this is a Swiss bank. And that obviously can be done also for global decentralized organizations. If they feel that there are people in Switzerland who have a pull, they can draw basically everything, all activities into Switzerland and make you responsible for it. And that is where the risk starts. And that is also why, for me, it's so important that there is clarity also from the regulator as to how they see it. And Uniswap, I think, would be a difficult case possibly to argue. If you have first layer protocols like Ethereum, which do thousands of projects, and projects go in all different directions, and not everything is financial market, I would argue with the purpose. I would say it was the purpose of Ethereum was not to have any kind of financial market infrastructure in place. That was not the basic concept which was built.
So speaking about clarity, and maybe we can also put up slides, the slides up that you can better follow. So there was a guidance in December, or recommendations by IOSCO, so the International Organization of Securities Authorities, that basically gave recommendations on how regulators should deal with decentralized infrastructures. So it's very an extensive paper and also very interesting to read. I mean, of course, it's the regulator's view, so it's more in the direction of course, if there is a financial market activity, if there is financial services, must be regulated, no matter on how you do it. And then also, FINMA came up with these anchor points, which look like as they are coming out of the considerations in the IOSCO, which are a little bit more concrete. Of course, it would be interesting, and can you go one slide further? Another slide? Of course, it would be interesting to see first from Amy, from a UK and European perspective, what you think about the FINMA anchor points. Do you have something similar in the EU or the UK?
So looking at the FINMA anchor points, they're very similar to the established case law and guidance that I talked about for the arranging activities, because they're, and again, coming back to this mere conduit exclusion, and it's very similar because again you would look at which services are being provided specifically. You would also look at who profits from the relevant activity, and all of those would then be arguments for the regulator against you being able to rely on this exclusion, on the mere conduit exclusion. So I think generally the FINMA points, but also very much the IOSCO recommendations are very much in line with the UK regulatory practice. Also, what I really liked about the IOSCO paper, I think it was written by a regulatory lawyer, not a policy person. So what I really liked about that is they also said there will nearly always be a person. You will nearly always find the person, regardless of how decentralized it is. If there's an activity, you as a regulator will find the person. And that, I think, is how a UK regulator would, and also a EU regulator would probably approach that.
But then it's a bit of a pity that they don't say this a bit more clearly. You put all of these criteria and say, well, there might be a responsible person here and there. Okay, but maybe what would be good if the regulator said, look, we are highly skeptical about this. Please convince us that there is a project that doesn't meet all of these criteria and that is truly decentralized to the point we cannot regulate it, but so far we have not seen it. And maybe they should go a step further to help us sort of understand where their views and be clearer about it and say, look, if we think the project has an activity that is regulated, we will seek in tandem with our fellow supervisory authorities abroad, we will seek to identify who can be deemed to run it or to facilitate it or to aid and abet or whatever construct they want to use and bring it down. Because I think here we are a bit playing a game where we're not saying clearly this is not all right, but between the lines, this is what I read, that FINMA thinks that there are no projects decentralized enough to be deemed unregulated.
I really like what you're saying, because I think that's exactly the point. And now, Catrina, to you, I think you or Amy mentioned before that if you generate revenues out of something, so let me challenge that and just say, I mean, if you license a software to a market maker, you also generate revenues.
Mm-hmm. Yeah, I mean, I think this anchor point is basically trying to put a different word to what they have used in circumvention, which is this group idea that there are people behind it. The interesting thing in the traditional way of business, if that group would go away, the activity would go away. In the decentralized space, I think the big question would be, what happens if, does the anchor point have to be conditio sine qua non, meaning if you don't have the anchor point, it doesn't work anymore? Because only then it is really an anchor point. Or do you take everybody who is earning money from it, who could be a service provider, who can also fall away, but the software runs on? Is that also an anchor point? So and on that, it's not specific enough, you know. And I think they're trying to put a word to it which actually doesn't lead to any clarity. It's just another word for their general circumvention. If there's somebody there who is doing something we don't like, we will take him.
Yeah, I mean, it's very unclear whether you have to fulfill 1, 2, and also the intensity. So I'm the opinion, it doesn't matter how many you fulfill, but it's about the intensity. But FINMA never said anything about that, and they just said, I mean, these are the anchor points, we are looking at that, and we believe that if it's a relevant activity, then it should be regulated. The question is, can we enforce it or not? It's very unclear. I don't know, Emmy, do you have in the UK or the European Union, do you have a different approach on how they deal with this?
Yeah. I think the reason why it's so unclear is that you just can't be clear, and I think that's the problem. And I think the regulators very much do not want to be clear, because they do not want someone to stand up in court and say, well, in this guidance you said this should be fine, and now you're saying it's not fine. So I think that's why there is, I don't know the intention obviously behind what the Swiss regulator did, but if I were the Swiss regulator, I would not want to be too clear. I would just say existing concepts apply and will apply appropriately. And it's that appropriately which can take so many guises in so many circumstances that I think is a little bit tricky. But from the UK perspective, again, it's really all about the mere conduit. It's all about if you are just like the internet, you're not regulated. If you go beyond what we have established case law, which will be applied appropriately, then you will be enforced against.
But I think those anchor points or those elements are not really a substitute for the broader thinking, in rethinking of financial markets laws in light of new technology developments, and whether we still need to view a trading platform as something that is operated by a group of people who are in a room and receiving orders and approving transactions or being able to influence them. I think there is really a need to look at what technology can do to de-risk some of these activities, and whether the regulatory framework that we have, which is extremely heavy and based on the idea that you have, 1, 2, maximum 3 stock exchanges in a country the size of Switzerland, whether this is still appropriate in a world where you can have some certainty that your infrastructure works based on properly designed code.
And I think the other thing I tend to struggle with in the regulatory approach in the recent years is that, at least in Switzerland, there was a big discussion on whether regulation should be social protection of the individual investor, or whether it should ensure the functioning of the financial markets. And my feeling is all these regulations of peer-to-peer networks, in particular because DeFi allows so many parallel networks. We're not talking about the functioning of the financial markets anymore. We're talking about social protection of the investor, and that should not be the role of the regulator. I think there you should leave it for peer-to-peer infrastructures to be able to continue to be able to develop, and leave it to the investors whether they want to use Uniswap or not use Uniswap, So I think that is where there's a fundamental underlying shift on the role which the regulators are taking upon themselves, which I think is not governed by the actual ideas of the law.
Yeah, and I think it's also interesting what you said, Ariel. You focus back on the activity, and if you look at these requirements or anchor points, I don't think so they have a real link to how the law defines an activity relevant to the financial market. As we are running out of time, I think one important topic I would like to discuss is how should regulators deal with decentralized infrastructure. I know, Amy, in the UK you have the sandbox regime. Maybe you can quickly explain it. Is that already basically you running into the mouth of the regulator and going or losing the fight, or is that something you think makes sense?
I personally think it actually does make sense. I think in the UK, as I said, the approach is look at the activities, is it regulated or not? If it's not regulated, you're fine. If it's regulated, then so you potentially have a problem. And that is what also the regulator recognized. So for those, and only for those, activities that would otherwise be regulated, there's now a digital securities sandbox, which allows, I would say, aspiring financial market infrastructures to start their operation. So, for example, you can apply to the sandbox and become a CSD. You can apply and become a trading venue in the form of an MTF or an OTF, and then you can do that in reliance on, as the FCA call it, developing technologies, which means that certain requirements where the FCA and the Bank of England recognize that certain requirements under the law, under the CSDR regulation or MiFIR, do not work for new, innovative financial market infrastructures. Those are disapplied, and then will be applied in phases. And the other point about the sandbox that I think is really interesting is it's not just for the for market participants to sort of play in the sand, it's also for the regulator to play in the sand, because one aim of the sandbox is for the regulator to learn which of the rules do apply neatly, which of the existing rules do apply neatly and can be applied by innovative financial market infrastructures, and which ones don't. And they already have identified a couple that don't. For example, under CSDR, you need a book ledger system, which obviously does not work for blockchain CSDs. And the idea is that then at the end of this process, the participants will exit this sandbox as fully fledged MTFs, OTFs, or digital CSDs, which we call DSDs, interestingly. And also the regulator will emerge from the sandbox with potentially a new regime for these technology-based financial market infrastructures. So I think this is a really exciting initiative. There are a couple of clients that we are advising already. It's open from autumn 2024, and a number of market participants are already preparing the applications.
Very interesting. Now, a final statement from Catrina and Ariel. Do you think, what should we do in Switzerland? Does that make sense?
Absolutely. I think it would make sense. I think the important thing would be to then not put too many restrictions on these sandbox entities, like we have done in the banking regime, where the sandbox exists, but basically has been cut down to activities which don't really allow for revenues, so it doesn't really make sense. So I think there we would have to be generous enough to actually also allow failure. You know, if you do a sandbox regime and want to prevent failure, you would also not have people using it, because no risk, no returns, you know. And I think that's where Switzerland would have to have a generous enough regime that it actually gets used. But they could learn a lot from it. I think the idea that it's not only a user's sandbox, but also a regulator sandbox is very valid.
No, and I fully agree with that. I'm usually hesitant with sandboxes because it's quite a costly endeavor to put in place. And as you said, businesses may struggle to generate revenues. But here, I think it's necessary. And if to the extent possible, I even think that Switzerland should subsidize a lot of the work around this. Because I think the regulators and many people in the industry, and also me personally, I'm not sure we understand exactly what we are witnessing right now and what direction it will go.
Very good last statement. So thanks everyone for listening, and thanks all the panelists for being here.
Thank you very much.
And yeah, have a good rest of the conference.
Thank you. So, ladies and gentlemen, we're going to move directly to the last roundtable. Again, I haven't seen the table up front, so the roundtable will take place without the table. But it will be an interesting one nonetheless.